The basic purpose of criminal law is to establish limits on certain human behavior or activity considered harmful to society. It's not about oppressing people or preventing them from enjoying life. You should think of laws as being tools that we use to build and maintain an orderly society. If each of us lived in isolation, if we didn't make contact with others, there'd be very little need for the law. But in fact, we don't live that way. We live in a very complex society, and it requires daily interactions with many other people. In such a society, each person must know what he or she can or can't do legally regarding frequent contacts with others. Even in a complex society as ours, if everyone did the right thing, probably wouldn't need very many criminal laws. Unfortunately, there are those people that always attempt to oppress the helpless, who steal the possessions of others, or in one way or another violate the life, liberty, or property of others by force, fear, or fraud. In a way, you might say that laws are the social contract to allow people peace and freedom in their life. Development of the law. Sometimes people think about the Bible as being one of the first recorded books that had rules in it that people would follow. Actually, that was later on in history. But if you want to look at it historically, criminal laws came into being as a result of trying to control antisocial activity of some people. And if you think about it, it was the beginning of determining what proper social conduct would be. Most of our early law was based on custom and other recognized patterns of human behavior, which appeared to be beneficial to the group as a whole. Even today, laws pertain to incestuous marriages between closely related blood relatives can be traced to early tribal taboos. Other crimes regarding theft, murder, and child molest have a similar basis. Criminal law is almost as ancient in one form or another as humankind on earth. No doubt even the early caveman eventually established some sort of basic rules for who would eat first, who would tend the fire, and who would stand guard. Evolution of early law. Man formed into small groups for protection. 5 small men can beat 1 large man. And there were going to be some family rules and morals that would conflict. New rules had to be developed to manage the conflict. As family groups eventually joined one another to form tribes, new rules and laws were developed to avoid conflict to ensure the peaceful functioning of the group. Children were no doubt taught local customs and taboos by parents or other members of the tribe. As society developed and began to place its thoughts in writing, there emerged the concept of statutory or written law. Trade also affected laws. As trade developed between different societies, laws were developed in written forms to control smuggling and tariffs. What makes a good law? It does the most good for the most people over the longest period of time. History of law in early civilizations. We're going to be looking at a variety of early civilizations and comparing, contrasting the sort of laws that were developed there. The first society we're going to look at was Babylon, because it had one of the famous kings who developed written law and many other things. King Hammurabi was a very intelligent king. He used science, math. He's responsible for coming up with time, 24 hours in the day, 60 minutes to an hour, 60 seconds to a minute. He also developed a written language and saw to it that his people learned how to read and write. He came up with the thought about If someone hurt you, you could hurt them back. An eye for an eye, a tooth for a tooth. Also came up with the idea of the Code of Multiple Retribution, which meant that if you stole a pig from me, your fine would be that you would have to give me 3 pigs back. He also wrote laws that dealt with consumer fraud. Some examples of some of his laws included that if a house was on fire and a person who was helping to extinguish the fire stole an article from that home, that person would be killed and buried at the front door of that home. That if a bartender was to serve less than a full glass of ale, that he would be punished. Hammurabi was very interesting. He developed stone tablets that were placed around a gigantic statue of him holding a sword that was placed in the middle of his town square. The citizens of Babylon were required to know all the laws associated with the Code of Hammurabi. We could trace many of our legal concepts and procedures back to the Code of Hammurabi. These include making perjury a crime, written contracts, juries and judges, and the swearing in of witnesses. Again, Babylon society was one of the first to use written contracts. They had separate juvenile courts, the legality of witness statements, and swearing of oaths before God. They also established inheritance rights and homesteading land. You can find some links if you Google the word Hammurabi, Hammurabi. You'll be able to actually find copies of some of the laws that he developed. In Egypt had police who walked around the street. They believed in corporal punishment. They used a club, what was called the bastinado. And what they would do is if they believed that you had committed a crime, they would immediately investigate. The 2 officers would consult each other. They'd hold a quick trial right there and determine your guilt or innocence and punish the offender. Examples of the punishments were that they tend to favor immediate punishments. You get, for minor crimes, you would work on public work projects like building pyramids. If parents killed their child, they had to tie the dead baby to them and carry it for 3 days. Adultery was very serious. Women would have their nose cut off and men would have to suffer 1,000 blows with the bastinado. A special iron club for the privileged rank was developed, and thieves or forgers could have their hands cut off. Hanging was common. In Israel, the Mosaic Code was written by Moses and included the 10 Commandments. Things like 6 years you shall sow your fields, on the 7th year you'll let the land rest. They also believed in eye for an eye and equal justice to all, including strangers. In most of these societies, you have to realize that there were castes. There were the rich and there were the poor. If a rich man was to kill another rich man, that man would give up his life. If a rich man was to kill a poor man or a slave, that man would have to pay homage to the owner or family. In Greece, you had draconian law. This is 621 before Christ. Draco was a very, very eccentric king. He believed in severe punishment. Theft and murder were held to the same punishment, which was death. Many of the judges were reluctant to find people guilty of crimes because Draco would kill them. One of his aides once asked him, "King, why do you sentence everyone to death?" And he said, "I can't think of anything more severe." In Ceylon, this is 639 to 559 BC. A lot of these societies used the Code of Hammurabi as a basis. They had multiple retribution for crimes against property. Idleness, or being a bum, basically, was a crime. Prostitution was allowed, and divorce was allowed, but adultery was severely punished. They also had many of their laws in a written form, statutory form. Roman law. In Rome, you had the law of 12 tables, inscribed on brass tablets and hung in the temple of Jupiter. Rules of conduct were established there. They also believed in multiple retribution, choice of suffering a punishment or same injury as a victim. So if you stab someone, you could choose your punishment to be a stabbing. Pay debts or paraded around town and put to death. Rome developed a jury system which was called the judices. These were groups of juries that traveled around Rome to hear cases and weigh evidence. Usually 9 people were in a jury, and they determined the guilt or innocence of people accused of crimes. In Europe, you had the Dark Ages and feudal law. Usually you had an area divided up, and each area would be similar to what we have counties in Northern California, had a lord or a knight that was in charge, and that person would have to determine the guilt or innocence of anyone in their area of control. Common law started to be developed here. It's unwritten law formed solely by usage and by custom developed in a particular area over time. So some of the things that would happen is an offender would be taken before a lord or judge, and they had to do 2 things: determine guilt or innocence, and second, what the punishment would be. So if you steal 3 chickens and you're going to be whipped 50 times and have to give back 12 chickens, that would be common law. That would be the custom. The invasion of England. Christianity was not accepted by the Romans, and any activity of the church had to go underground. In 313 AD, the Romans discontinued persecution of the Christians, stopped throwing them to the lions, and the bishops of the church involved themselves in politics and soon became very powerful. They had 2 types of law at that time. You had the king's court and the ecclesiastical court. The ecclesiastical court was the court of the church. Accusatory juries. William the Conqueror came to England in 1066. He was a French military leader that conquered the British Isles and declared himself king. When he got here, he found that the territories were divided up and put under the jurisdiction of the reeves. So what you had was you had shires. If you remember the story of Robin Hood, you had all these shires which were similar to counties, and you had a reeve in each shire, and hence the word shire reeve, which eventually became sheriff, was established. And he did some interesting things. When he replaced all those shire reeves with his knights, he found that the people were not cooperating in bringing guilty parties to justice. Why would you? You'd just been conquered. And so what he did was a couple things. The first thing was he told the sheriffs that they had to act in the name of the king. That was one thing that he did. And he placed all the courts under royal control, and he invited the common people of the country to seek justice in his courts. This has never been done before. So he actually used bodies of persons from the community to go out and obtain criminal information concerning the areas they lived in. This became known as the grand jury. The hue and cry. One of the ways that you would catch a thief back then was that if someone stole something, you'd yell, "Stop, thief." And under the king's orders, you were required to give chase and try to capture the criminal. Trial by jury. Smaller jury of 12 eventually decided the guilt or innocence of those accused. Um, William the Conqueror did not believe that the jury that went out and collect the evidence to have the person arrested should also decide their guilt or innocence, because they'd already be prejudiced. And so he formed another jury, which was known as the petite jury, that would decide whether or not someone was guilty. King John took over the reign of England in 1199 AD after Richard the Lion-Hearted, who was a very much loved king. And conditions under his rule became unbearable for both the nobleman and the commoner, because what he would do is he came up with a law that basically said that if you violated the king's law, that you could forfeit all your lands and monies. And then he would make up laws, and he would go backwards in time, claiming that he would be able to go after your property. This wasn't a big deal when it was only the commoners that were being dealt with in this situation, but when they started to deal with the noblemen, it became a controversy. So convicted offenders of the law forfeited their property. In order to increase his wealth, made various acts of crimes in order to confiscate property of others. Now, what ended up happening was he was coming back from some sort of a party, and he was captured by noblemen and forced to sign the Magna Carta in June 15th, 1215. Later, he was able to get the Magna Carta annulled by the Pope because he cried that he had been forced to sign it, and he ended up being poisoned a year later. And kind of interesting how that one ended up. Some of the guarantees of the Magna Carta were that no free man shall be seized or imprisoned except by judgment of his peers or by the law of the land. That the charge would be reviewed by a grand jury made up of members of the community. That guilt or innocence could be determined by trial by ordeal or trial by battle. Trial by ordeal. I don't like this one. They tie your hands and feet together and throw you in a rushing river and see if you survive. They had other ones where they would have you stick your hands in pots of boiling oil and then wrap them for 3 days, and if you had no scars or blisters, then you were supposed to be innocent. You have to realize that a lot of this had to do with these cultures believing that God would protect you if you were innocent. Another example of trial by ordeal, on the rack, stretching someone. If they don't suffer any damage to their body, then they're innocent. God will protect. Trial by battle, of course. So if you had some skills out there on the battlefield and then you were accused of a crime, this would obviously be a good way to clear your name. Habeas Corpus Amendment Act of 1679. Now, one of the things that was happening was that spies would go out and bring the king evidence of treason and rebellion, but a lot of it was just rumor. They turned this list into the crown, and the persons would be imprisoned and tortured to confess. What the Habeas Corpus Act means is that if there is evidence of someone did not do something, or that if you're going to charge somebody, it has to be based on facts, not speculation. A judge gets to review that, and if the person's in prison, they get brought before the judge. You hear about habeas corpus acts where new evidence is found on someone's case who's currently in San Quentin serving time, and they file a writ of habeas corpus to have a judge review their case and have them released if it's shown that they're innocent. Now, Napoleon, we're going to talk about him for a minute, jump a little bit forward, but 1804, he wrote what was called his civil code. In most societies, we're going to be talking about civil and criminal law, and they're usually, in the United States, it's separate. Napoleon, every country that he conquered, especially if you look in Latin America, Mexico, they use his code. And what it is it's a mixture of the two, of civil and criminal law. Uh, an example would be that in the United States, if I had a roofer who was supposed to fix my roof and he did a terrible job and takes my money and I'm not happy, I take him to civil court to get my money back or get damages from him. In Mexico, that's not so. If the person rips you off and does a terrible job on the roof, that person might do jail time because the civil and criminal laws are mixed. Colonial law, pre-revolution. King James was the king of England in 1619, and you had the Puritans who left England and established the Massachusetts Bay Colony. For the most part, they used the Old Testament of the Bible as their constitution. Any criticism of the leadership or deviant behavior was given severe corporal punishment, including the use of stocks. Now, stocks would immobilize you at the head and shoulders, and you could be standing or you could be kneeling or you could be sitting, and they had what was called outlawry, which meant that you were out of the protection of the law when you were in the stocks. So if you were left out there at night, particularly women, you would be at the mercy of any passerby. Imprisonment was another form of punishment. Hanging was another form of punishment, and this was usually done in a public spectacle that would bring many people to come and watch, and it was thought that it had a deterrent effect. In 1641, capital offenses that you would be killed for included worshiping any other god, being accused of being a witch, blasphemy, which is taking the word of God in vain or speaking up that God doesn't exist, something of that nature, willful murder, not self-defense, bestiality, which is sex with animals, homosexuality, adultery, sex with a child under 10, rape, theft, bearing false witness, or rebellion, sedition. In 1774, there was a Declaration of Rights that was written out because the colonists had certain concerns. They wanted to have the same sort of rights that a subject of England had, and they felt that their children should have those rights also. They weren't represented in Parliament, and so it was really easy for Parliament to raise taxes, or the king to raise taxes. They felt that they were entitled to English common law and to be tried by a jury of their peers. Colonists were being denied rights via royal charter, and they were not allowed to assemble and grieve redress. So they wrote out the Declaration of Independence, and the war was on. Reform Act of 1832. Precedence and stare decisis. Precedence basically is where the common law comes into. Let's define the common law for you. It's defined by Blackstone. Common law consists of doctrines that are not set down in any written statute or ordinance, but rather depend upon long-time usage for their authority. Common law is obviously much more ancient than statutory law. It can be described as a total of doctrines, decisions, precedents, reasonings, and practices comprising of the legal heritage of Anglo-American law and the source of legal thinking. The common law, in the sense in which it is used here, can be described as the body of law which gets its authority not from express enactments of the legislature like statutory law, but from the fact that it existed for a very long time. So when you look at the Reform Act of 1832, what it said was that they started to recognize precedents, which is also known as stare decisis. Key terms for this lecture: Code of Hammurabi, Law of 12 Tables, the Judices, Common Law, Feudal System, Napoleon's Civil Code, Ecclesiastical Law, Accusatory Juries, Petite Jury, Magna Carta, Habeas Corpus Amendment Act, Stare Decisis, Blasphemy. This is the end of Lecture 1.